Good morning, everyone. On behalf of Securus, I welcome you all to the webinar on new labor code, what HR and IC must act on now. A few housekeeping instructions before we start the session. I request everyone to keep your phone on silent and switch on the cameras. If you have any questions or queries, please feel free to use the chat window. They will definitely be answered at the end of the session. You can also express your thoughts and emojis in the chat window, and that will make the session an interactive one. For any suggestions and feedback, please write to us at connect@securus.com. A quick introduction about Securus. We at Securus ensure creating safe and harmonious workplaces through our four offerings: PoSH, DEI, EAP, and COC. Our PoSH program ensures that the workplace is free from all forms of harassment. Our inclusive diversity program implements an inclusive and diverse work culture. Our employee assistance program is designed to identify and assist employees in resolving issues that may be affecting their work or personal life. We also specialize in helping organizations implement code of conduct frameworks through customized workshop training, policy development, and e-learning modules. With that note, I extend a warm welcome to Ms. Ashwini, the facilitator of today's session. Ms. Ashwini is an independent practicing advocate with experience in litigation, advisory, and dispute resolution. Her areas of expertise include corporate complaints, labor law, contract drafting, and intellectual property advisory, and she advises organizations on regulatory complaints, trademark protection, and workplace governance practices. She's a certified PoSH trainer and actively conducts sessions for corporates and in academic institutions on PoSH. She also conducts sessions on cyber law and related legal topics. Over to you, Ashwini, for an informative session.
Good morning, all. Thank you, Mahalakshmi. Thank you for the introduction. Once again, my name is Ashwini Ajay Kumar. I am from the Securus team, and I'm also a practicing advocate at Madras High Court. So it's a pleasure for me to be here today with all of you to discuss on the new labor code. All of you are industry experts, so I hope we'll have a very insightful discussion today. So when we talk about this new labor code, it is one of the most significant labor law reform that has happened in the recent years. This new labor code is going to influence the way the organization manages employment, wages, and various other factors that is important to the organization. So in today's session, we will be going to look at what are the different codes that is introduced under the new labor code 2025. The practical aspects that the HR team and the IC members should be aware of, the likely implementation challenges that the organization may face, and what the organization should proactively do to overcome these challenges. So these are the things that we'll be going to discuss today. I hope, Mahalakshmi, we have like most of the participants. Then in that case, we may start with the session then.
Yes, Ashwini, we can start.
Okay. Please allow me to share the screen.
You have the access, Ashwini, to share.
Yeah, thank you, Nirjal. I'm just getting it started. Can you all give me a thumbs up if you're able to see my screen?
Ashwini's screen is not fully visible.
Month. Is it good now?
Yes. Thank you.
Thank you. So as I mentioned, we'll be trying to understand what this new labor code is, and then we will look at the challenges and how we should overcome these challenges. Now, this new labor code 2025, all of you would have by now gotten some level of idea of what this new labor code is. So this has come into effect in November 21, 2025. So if you ask me, the code has come into effect since November, but it is still in an stage where we are still migrating to the new labor code, because the rules notifications are still under the draft stage, and it will be sooner be notified. But the organizations have already adopted this new labor code and has been migrating to the new labor code. So now let us look at what this new labor code is about. So before we understand any legal reforms, we need to understand why this came in at the first place. So there was, if you look at, we already always had labor legislation since 1990s, or even 1920s, we were having various labor law legislations. So why was there a necessity of this new labor code now? Now let us look at the reason why this has been implemented, this reform has come into place. So firstly, it is about the legal framework. So earlier, prior to this new labor code, we had 29 separate central labor laws. Now, this new labor code is trying to consolidate the 29 central labor laws into 4 different codes. So, what the legislation has done is that they have categorized the labor related issues into 4 categories. We'll look into that 4 categories in detail in the coming slides. But to understand now, there are 4 categories, broad categories that the legislatures have put out. And under these 4 categories, based on the nature of this existing labor legislation, it is being now brought under these 4 different categories, which is now called as the codes. Now, this 29 central labor laws, if you ask me, it is not replacing, the new labor code is not replacing this 29 labor laws, but it is actually subsuming this labor laws to bring in a simplified, unified framework. So if like several provisions, several laws which was earlier in existence is still now under the same manner under the new labor code, but with certain additions and modification. So it has not completely replaced the labor law, but it is all brought under the ambit of this 4 new codes. Now, the another reason why we had to introduce this new labor code is the coverage aspect. So if you look at the old labor laws, these are all very old enactments. So if you see the Employment State Insurance Act, it's of 1923. The Maternity Benefit Act is of 1961. So the old legislation did not address the modern labor issues. So there was a need for a legislation which is up to date, addressing the recent modern labor issues. So that was also one reason why we had the new labor code. Now, because as it did not address the modern issues, today's employment, the nature has changed a lot. Today, we have variety of employment opportunities, which was not in existence in the earlier times. Earlier, the employment was more of traditional nature, just an office supervisor, manager. These were only few cadres which workers category, all these were only the categories of employment that was there in existence earlier. But with the modern times, there's no lot more employment opportunities that is been created, like how we have gig workers now, online content creation, influencers, like there's a lot of new job titles that is there today. So the coverage also is expanded under the new labor code. Now, if you look at the uniformity angle, so as we had earlier 29 separate labor acts, there is, of course, room for ambiguity. Like same terminologies has been defined differently under different acts. So this led to a lot of confusion and lack of clarity, which this new labor code is trying to remove by bringing in by an unified code. A definition is given under one code, which will be applicable to all statutes under different codes. Now, so this new labor code has made the process simplified and uniform. Now, again, with respect to the complaints and reporting aspect, earlier we had to maintain paper-based reporting system, which slowed down the process, and inspection was difficult. All of this was the drawbacks of the earlier system. Now, if you look at the new labor code, it has brought in a single window registration system where a single registration is sufficient for different statutory benefits. Then complaints is also made digital, record keeping is made digital. So it will also enable the inspectors to check if the organizations are compliant by online mode itself. So a lot of administrative burden is reduced in the new labor reforms. So initial phase, it might be difficult for organization to adopt everything to migrate to the digital setup. But in a longer run, this is definitely going to reduce the administrative burden on the organization as well as the for the labor offices. So this is why this is the main reason the legislature's intent to bring out a new labor code was to resolve these problems. Now let us look at what are these 4 labor codes. As I mentioned, these 29 laws are now unified into a framework categories under different codes. That is, mainly there are 4 codes. So we have code on wages, we have industrial relations code, we have code on social security, we have occupational safety, health and working condition code, which is also in short called as the OSH code. Now, code on wages, as the name suggests, any earlier laws which is relating to the wages is now subsumed under the code on wages. So you can see in that slide where what are the laws that is being subsumed under the code is mentioned. So if you look at it, the Payment of Wages Act, the Minimum Wages Act, the Payment of Bonus Act, the Equal Remuneration Act, these four acts has been now subsumed under the code on wages. So all these 4 acts were earlier relating to wages. If you see, all the similar provisions will also be found under the code on wages with certain modification to tackle the modern law issues. Now, secondly, we have the Industrial Relations Code. So Industrial Relations Code deals with industry related disputes. That is, earlier we had the Industrial Disputes Act, Trade Unions Act, Industrial Employments Act, Industrial Employment Standing Orders Act. These 3 acts are now subsumed under the Industrial Relations Code. This is primarily dealing with factories, trade unions, such kind of retrenchment, layoff. These provisions are being covered under the Industrial Relations Code. Now, thirdly, we have code on social security. So social security code is nothing but all the social security schemes and benefits that's available to the employees, such as insurance, compensation, maternity benefit, gratuity, provident fund. These are all social security benefits that's available to the employees. Now, all these such social security related legislations is being now subsumed under the code on social security. There are total of 9 acts which has been subsumed under the code on social security. Lastly, we have the occupational safety, health and working condition code. So the OHS code covers the safety security, like for industries or factories that is dealing with hazardous environment, how a worker should be safeguarded in while working in such organization. So anything relating to the safety, health and welfare of the employees is now covered under the OSH code. So this code has subsumed 13 acts. Earlier acts is now brought under the ambit of this OSH code. So now if you see the acts it has subsumed, the Factories Act, the Plantation Labor Act, the Mines Act, the Working Journalist Act, the Motor Transport Workers Act. See, different categories of work had specific laws earlier. This will definitely lead to a lot of ambiguity because the same thing has to be defined under every act, then there will not be any uniformity. Now, irrespective of these industries, like there is no industry specific act now. Instead, what they have done is under OSH code, they've brought all these journalists, mines, motor transport, everything under the definition of worker, and they have now uniformly applying this OSH code for all these industries. This is how they have tried to simplify the code. Now, so I hope we are now clear with what are the 4 different kind of codes. We look into it detail and what is the key changes that has been brought in under the each of the code. So now let's start with the code on wages. So code on wages, there is a clear definition for wages that is given under this code now. This wages definition under this code is what is going to be applicable for all the codes. So if you refer to section 2 clause Y of the code on wages, that gives the definition of wages. We'll look into the definition in some time. Secondly, it talks about gender equality. So if a woman or woman who works in the same manner for the same value should be paid equally. So this is what was earlier under Equal Remuneration Act. That is being now put under the code on wages as equal pay for equal work. Now it also specific code on wages also give a timeline, a mandatory timeline for payment. So when you talk about wages, like wages needs to be paid, minimum wages needs to be paid, but when it has to be paid, the employers now cannot take their own sweet time to keep the wages payment pending. And though there is a wage period, there is a timeline for payment of wages depending on the wage period, that is whether it's a daily wage, weekly wage, monthly wage, so and so, whatever be the category. Now the new code has fixed a definite timeline for payment of the wages. So in case of daily wage workers, it says that the code mandates payment of wage on the same day of work. In case of weekly wage workers, the payment has to be made within 2 days from the said weekend. For monthly wage workers, the payment has to be paid by 7th of every month. So there are organizations that follows different wage period, like there are organizations which pay wages by 10th of the month. Such practices cannot be permitted now. By 7th of every month, the wages has to be paid. And there is also an introduction with respect to the full and final settlement. So the code on wages mandates that all wage related aspects in a full and final settlement has to be paid within 2 working days of termination or resignation. So in case an employee resigns, or is terminated, or if is removed from employment, whatever be the case may be, the full and final settlement has to be paid within 2 days. That is the new mandate. But also, that full and final settlement payment is only relating to the wage aspect. So whatever is the allowances, wages that is pending needs to be paid in 2 days. But with respect to gratuity, PF, and other statutory benefits, that it have its own timeline. Say, for example, gratuity as per the code on social security, the gratuity has to be paid within 30 days of separation. So such other benefits, such as the statutory benefits, which is not part of the wages, can be paid separately. But with respect to the all wage related aspect elements, it has to be paid within 2 working days of termination or resignation. This is the what is provided under the new law, and it is made mandatory. Now, so this is the compliance timeline under the new wage code. Now, looking at the wage structure changes. So this is one of the very key changes that is being brought in by the new labor code. And this is where the HR and the payroll department is now breaking their heads to how to revamping their wage structures to fit into this new labor code. So firstly, they have introduced a 50% basic pay requirement. So as I mentioned, wages, if you look at the definition of wages under section 2Y, it says wages include basic pay, dearness allowance, retaining allowance. So these components jointly together should form 50% of the CTC. Now, a lot of organizations today, if you see, they are paying wages in form of various other allowances in different name, compensation allowance or travel allowance, in different names. It is been, but it is all being provided as perquisites or allowances. Now, in case if the organization is paying allowances, that allowances put together, if it crosses more than 50%, that excess will be added towards the basic pay. That is what the new wage definition and the basic pay mandate requirements states. Say, for example, if a basic pay of an organization is now fixed at say 30%, and the allowances put together, if it is coming to 70%, then that excess of that 50% in terms in the allowance category, that 20%, that is 70 minus 50, that 20% will be added back to the wages. So then so that the wages attain the mandatory requirement of 50%, and thereafter all the statutory benefits such as PF, gratuity, and all of that will be calculated on the 50% wage. Basic is how the new code works. Now, similarly, how basic pay requirement is made mandatory to 50%, there is also a mandate on deductions. So deductions are nothing but if an employee is being fined, penalty, any house rent allowance, any loans and advances taken from the organization, or any loss of pay, any loss to the company property. So all of this will be deducted from the salary. Now, the deduction limit is also capped at 50%. So, during a wage period, that is in that 30 days, what the employee can claim as maximum deduction is now capped to 50%. So, like how basic pay is now capped to 50%, deduction limit is also now capped to 50%. So if in excess, if there is any deduction, the act does not, the code does not prescribe how that has to be handled. But in the coming times, we'll see how the organization are handling, or the rules might provide for it. But ideally, what can be done is, if there is any excess deduction for that month, it has to be carried forward to the next month, or there should be in other ways that the organization needs to handle it. But now the current wage structure stands at basic pay has to be 50% and deduction limit has to be at 50%. So the issue that has sprouted here is that a lot of employees now feel that their take home salary is going to be less, because more basic pay, then more PF deduction, so what they're going to get in hand is going to be less. So this is where employees, there is an unrest that is seen in the employees because of this change in the wage structure. But we'll also look at how to tackle all of this in the coming session. But for your understanding, now the code has made it very clear that the basic pay has to be 50%. Now, in addition to monetary consideration, if organization is paying any in-kind remuneration like food coupon or any accommodation separately, such benefits has to be, there is also a cap on giving such benefits in remuneration in kind to an employee, that is limited to 15% of the total wages. So this is the main changes in the wage structure. Now, there's also dealing with other provisions of bonus and overtime provisions. So bonus eligibility is same as the earlier, how we had it earlier. So if an employee has completed working for 30 days in an accounting year, they'll be eligible for bonus payment. And the bonus rate is calculated at a minimum of 8.33% to maximum of 20%. There should be a minimum bonus that has to be paid by the organization. Similarly, with respect to overtime also, so the normal working hours has to be 8 hours in a day. But now the new code allows that the normal working hours can be stretched up to 12 hours in a day. In the 12 hours has to be including the breaks, and maximum weekly hours should be 48 hours. So maximum of 48 hours an employee can work in a week. So 8 hours can be stretched up to 12 hours, but including the rest intervals. Now the code also proposes that in case the organization is following a 12 hours work rule, then they can even consider working only 4 days in a week. So a 4 days work rule is also possible under the new labor code. But in that case, an employee will be working 12 hours. But 8 hours is always found to be ideal. So normal working hours is 8 hours. But now the code allows up to working of 12 hours and a maximum of weekly hours at 48 hours. So in addition to the access to anything rather apart from this 12 hours, it will be considered as overtime, and whatever is their hourly rate of wages, the double that hourly rate of wages has to be paid to them as the overtime benefit. Now, under the wages code, again, regarding the record keeping requirement, like as I initially mentioned, now all the records has to be maintained digitally. So we have, under the wage code, we have different records such muster roll, wage register, overtime register, register of fines, deduction, all of this. All these have to be now maintained digitally, and these records have to be preserved for 5 years. So depending on the records, there is a timeline that has been given for maintaining this record. Now that it is earlier, it was difficult to handle because it was had to be kept physically. A lot of times in labor courts, when these documents were summoned, the organizations were unable to produce it before the court. But now it is all made digitally, so organization has to find ways to preserve this documents digitally. I hope you're clear with wage code. In that case, we can move to the next code, that is the industrial relations code. So if you look at the industrial relations code, that is the second code. As I mentioned, this is a code which is dealing with factory workers category. So it deals with industrial relations, it deals with trade unions act and so on. Now there is, under the industrial relation code, there is a grievance redressal committee, which is a mandatory committee. Now, grievance redressal committee, what is the purpose of this committee? As the name suggests, it is to redress grievances of the workers in an industry. Now, every industrial establishment which employs more than 20 or more employee, they need to constitute one or more grievance redressal committee. Now, what is the composition of this committee? So there should be equal representation from the employer and the workers. There can be maximum of 10 members. and there should be proportional representation of the women workers. So if any worker has any grievances, they should report it to this grievance committee within 1 year from the date of occurrence of that event. So 1 year is the cause of action is that has been mentioned. So like here you will have a lot of IC members who are handling PoSH complaints, where there we talk about a limitation of 3 months to entertain any PoSH related complaints, which maximum of 6 months time we can provide to any complainant to register such complaint. Similarly, under the grievance redressal committee, it allows the workers to file a complaint within 1 year from the date of occurrence of the event. So the limitation is 1 year. Now the committee has to conduct the inquiry following all due process of the law, giving the opportunity to be heard to the complainant, respondent, and following all the procedures, recording all the evidences. But the inquiry has to be completed within 30 days. So 30 days is the time for completion of the inquiry. Now, so this is one another important change that has been brought under the Industrial Relations Code. So, applicability of certified standing orders. Standing orders is nothing but the rules and regulations governing a industry. So, anything relating to what is misconduct, disciplinary proceedings, what is the code of conduct for the workers, all that will be mentioned under the standing order. So,
Hello, sorry to interrupt,
yes, please.
but I have a query. Like you said that the working hours can now be 12 hours. So if we have to pay overtime, so in a day the worker has to work for 12 hours because we are making that policy. And then if he is working about 12 hours, we have to we are eligible to give him overtime.
Yes,
Am I-
correct. Yes, correct. And this 12 hours is also capped at 48 hours in a week. So,
I understood. So that means he'll be working 4 days a week, correct?
yeah, if he works for 12 hours in a day, then he should be made to work only for four days in a week.
But in a day, for him, working 12 hours would be more challenging, right?
Yes,
Even if we are
correct.
giving breaks or something.
Correct. So the new code does not mandate that the organization has to follow a 12 hours rule. So earlier, normal working hours definition itself was 8 hours. Even now, the normal working hours is only 8 hours. It provides a room for the employers to stretch that working hours up to 12 hours, including the rest intervals. That too, every 4 hours there should be a rest interval. So including all of that, it can be maximum of 12 hours. So because if an employee is because there is a cap of 48 hours in a week, in case if an employee is going to work 12 hours every day, then he should be made to work only 4 days in a week so that it attains the maximum
Okay.
hours that he
So
works.
it's like from an employer perspective, you make him work for 8 hours, 5 days a week, or 6 days a week, or you make him work for 12 hours, 4 days a week, so that you save on the overtime.
Yes,
Am I
correct.
correct?
Yes,
All
correct.
right.
See, this
Thank
is
you.
also because a lot of organizations say they in papers, appointment letters, it will say 8 hours, but it mostly stretches because they'll have meetings beyond their working hours and so. So, like I mentioned, modern day labor law so needs modern solutions, right? So they've extended the working hours. It's that employees are also stretching their work hours in such a manner. So up to 12 hours you can stretch, but beyond that they are eligible for an overtime wages.
Understood. Thank you so much.
Okay. Yeah.
Actually, this is
Mhm.
Michelle here. I just had another question with regards to on-call support allowance. So, how
Mm.
does that really work when it comes to meaning it's not overtime, but if they're expected to be there for on-call support, in case of an emergency, and how will that get treated?
See, now this new labor code does not talk anything. It recognizes remote working, okay, but it does not talk about such. I mean, on-call support is also kind of a remote working because it is stretched beyond the working hours, then they're going to attend this call remotely, right? So
Correct.
even if someone works remotely, it has to be included in their usual working hours only. It cannot be seen separately.
Oh, is
So
it?
all put together,
Okay.
organization should make the employees work only for maximum of 12 hours in a day.
Oh, so even on-call now can't be taken separately.
Yeah, because it's still part of their work. And
Mm-hmm.
now, because in modern times we have this work from home, which is very prevalent. So, and
Mm-hmm.
the code also recognizes remote working. Like when you see Maternity Benefit Act and like in the Social Security Code, like the code itself says that if after maternity break, if the employees find it difficult to come to the physical space for working, then the employer should accommodate them to work remotely. So, in other cases also, remote working can be allowed. So, this will be now brought into the policies of the organization. Now, in that, if someone works remotely also, that forms part of the working hours only. So if
No,
someone gets an
but
on-call support also, it's
like
part of their working hours.
yeah, on-call support, but was more like says only if there's an emergency, right? But they have to be available on standby, so they need not be working unless an emergency really comes up. So will it be treated only the hours that they have really worked on can be added up as the 48 hours, or irrespective because they're going to be on standby for the night, we have to consider that as one full day working their 8 hours.
No, you can calculate based on the hours. That's not a problem. But even if you
Okay.
say that that employee was just on the call, he did not contribute, whatever that be, it is still that person is made to work. It's not like he cannot do anything outside of work at during that hours, right? That's allocated to the work. So in that case, it will definitely be counted as working hours only, even if it's an emergency support or whatever, however you term it. It is part of his working hours because he's allocating that hours for work.
Which is because he's on standby.
Now, even if it is standby, like if he should be available. See, if a standby, if you mean it in such a way that you have informed, say you are the one who's supposed to attend the call, but you have informed that if I don't attend the call, please be available to attend, but he did not attend at all. Okay,
Oh,
because
no, no, no. Okay,
in,
so
in,
my
in such
scenario,
scenarios,
Ashwini,
mm,
yeah, I'll just explain a scenario. So, for example, the RPA team that they work for, they work during the day, their normal 8 hours,
mm,
right? Then, say, supposing there is a situation in the middle of the night where they have to go and fix something, right? And one person will be there on a weekly roster,
mm,
right? So, but then one person says only if something breaks through the
mm,
night to
mm,
be available. So what is that considered? So only those hours can be considered to be plugged in as part of the 12 and 48 hours a week, or the fact that he was rostered for the week, irrespective of his morning shift, and then being rostered for the week for that night is considered as a separate 1 day working completely.
No, when you if whatever is the hours that he has worked, that only needs to be included. So in such
Only the
cases,
hours.
how you need to plan is that you have to see how many hours, how many employees were on standby. So in that case, like see, you can stretch up to earlier 8 hours into 5 days is now stretched another 8 hours, right? 48 hours now.
Correct.
So you can fit in employees. It's a matter of like a week. There'll be different employees who can be there on the call giving support. So 8 hours for so many employees will still you can fit into that that bracket of not going into an overtime wage payment. So that is how the HR needs to plan that should be put on. I mean, HR or the team needs to plan that who should be put on this onboard call, whether how much hours they've already worked additionally and all that. All this needs to be keep track of.
Okay, got it. Sure. Sounds good. Thank you so much, Ashwini.
Yeah. Uh, So can I move on? Any more questions on because
Yeah, I had put my question in the chat box that you mentioned about the grievance committee, right?
yeah,
Redressal committee.
yes.
Is this committee different from the PoSH IC team member committee that we have?
Yes. So this is different from grievance redressal committee is something under the what we see the Industrial Relations Code. PoSH Act is not even subsumed under the new labor code. It's not a labor legislation or it's not a welfare legislation. It is PoSH Act is enacted for a very specific purpose. Now that is separate from grievance redressal committee. So when we look at the challenges, what this new labor code will give is also one of this would be an misunderstanding, a lack of clarity whether these two committee will overlap. So that is also where the HR role is to handle these two committees parallelly. We will be actually discussing this in detail. If it is fine with you, like maybe in that slide, you can reserve your questions also because once I explain that.
Sure, sure.
Yeah.
And there was
Otherwise,
one
I'll
more
be jumping.
question. There was
Yeah,
one more question related to full and final payment that you've mentioned that the wages should be at least cleared within 2 days of the
correct.
person leaving. Now, and the other entitlements like gratuity and all can take 30 days or as per the timeline.
Yes,
But in
correct.
cases such as if an employee is not eligible for gratuity or other entitlements and they are just eligible for normal wage, so how are we going to clear this without receiving the asset? Because we collect the company asset that they use, and it might take time of receiving that asset beyond 2 days.
Yes, correct.
So without receiving that, how can we clear the full and final within 2 days?
See, I'll tell you something. Now, when this new labor code got enacted, earlier we did not have these provisions of full and final settlements to be cleared within 2 days. So most of the organization, if you see, they'll use a 45 to 60 days. That was like a standard rule for clearing a full and final settlement. Now, this has made this 2 days. It is very strict, stringent, and a lot of organization employees are already raised concerns regarding, like, they in the draft comments they have given that it would be practically difficult to implement. But what they're saying is only the wage related, like allowances and the wage related elements only, that mean those ingredients only needs to be paid within 2 days, and other statutory benefits can be settled later. But again, how HR and the team has to now bootstrap to, like, see how this can be implemented. So to how this to be implemented, what they can ideally do is that during the notice period itself, the team has to work on getting back the assets. I mean, towards at least the end of notice period, get parallelly, the department has to work parallelly to give the no due certificate and so on. So we have to come up with solutions that in such a manner that during the notice period we get an understanding of, like, how much should be the full and final settlement that needs to be paid to the employee, because this is a mandatory compliance that it needs to be paid within 2 days, working days. If not, there is a penalty of 50,000 on the employer. Like, if the employee raises a complaint to the labor officer that this is not done within 2 days, then the labor officer will give some time to rectify. If not, they will impose a penalty of 50,000. And if there is a repetition within another in a particular duration, if this is going to be a repeated offense by the company, there is higher penalty. So this is a very important provision which we cannot take it so lightly. So the organization has to rework on their settlement process, like how to speed up this.
But how can we take the laptop before the last working day? Because he or she would be assigned to the work that they're supposed to complete. If we ask them to return the laptop prior to their last working day, then
So I'm saying that laptop can be submitted on the last working day, but like after they submit it, there is an inspection that is being done, right?
no,
Maybe that
it
inspection.
is not possible to submit it on the last working day because most of the people work remote. They send it via courier. So there
Hmm.
are cases where people send it via courier and it takes time to receive, maybe 2 days at least. So
Mm-mm.
even if we send, yeah.
No, so we'll have to come up with some, if there is a regional office, before that there should be some inspection facilities that needs to be provided. Or we'll have to see, one thing is that practical, as I initially when I started, as I told you, this is only implemented. Okay, when we start, like as in there is it has come into effect, but the implementation is happening in a phased manner. So over time, there are high chances that such kind of rules there will be some flexibility, or when such challenges are courts giving such flexibility to the organization. But the problem here is that at this point it is going to be alarming to the organization is only because this is made as a mandatory compliance, and if not, there is penalty. So because of this issue, but these kind of provisions, we're expecting that going forward this is definitely going to have some kind of revisions because of this practical difficulties, like you said. What I said, like of inspecting the assets earlier, is possible when it is all working physical, like at a physical premises. But like you mentioned, when it is when the employees are working remotely, when they send the asset, is going to be difficult. So what ideally I would state is that you can still have such policies in your organization as an organization policy, like from the date of submission you can have this 2 working days, so that even if there is an compliance issue, like that from the last day within 2 days it is not been done, what you have to do is that ideally keep the communication moving. Like, other benefits, finance, annual settlement is calculated in such way. We are expecting your asset to be recovered, and after inspection of that, we will be calculating the value of this, and this will be the final settlement. So that at least that intimation can go within the 2 working days, so that the employees will not be inclined to take any, will not be inclined to invoke these provisions to take any legal action against the organization. So some way we have to like keep things moving is what I'm saying. Like not just wait for the assets to come, but is whatever can be computed earlier should be done. If it is only with respect to assets, you should also discuss with your organization to see if there is some other way we can handle this in terms of checking the devices. Or what we can also, you can have an asset recover policy where you mandate a particular deduction for assets, like so that in spite of whatever the condition be, you're anyway mandatorily deducting that. Or you should mandate the employee to come submit it to the organization before the last day so that can be inspected. It depends on how your organization works. Some kind of rules needs to be brought in.
Sure, thank you.
But maybe we just have to wait and see these kind of provisions. From what I have seen, I think we'll have some flexibility in the coming times. Because these rules and code, no, most of it, they're actually getting comments and input still from the employer team, employers, workers, employees, and all of that. So there will be some kind of relaxation to this kind of provision. But to start with, yes, the team has to plan, the organization has to plan how that can be settled in 2 days. Okay. So moving on. Now we'll be looking at applicability of certified standing orders. So as I mentioned, standing orders threshold earlier, if there is more than 100 workers, there need to be a certified standing order. Now that threshold has been increased to 300. So if in any industry which has more than 300 workers, only need to have a certified standing order. Otherwise, they can use the model standing order. But standing order is very important to an organization because the definition of misconduct, how the disciplinary proceedings happens, what are the punishments that can be given as an outcome of the disciplinary proceedings, all that is usually mentioned under the standing order for any industries. So it is very important to have all the organization to have standing orders, but now they have relaxed it to give that flexibility to organization to be not very strict on the standing orders. They've increased the threshold to 300 workers and more. Now, the Industrial Relation Code also talks about fixed term employment. So, fixed term employment is nothing but the contract employment. So, if any employee who works for a fixed period of time, they are recognized, they should also receive the same wages, same working conditions, same benefits as a permanent employee. And under the new code, it is also made mandatory that even the fixed term employment, under the fixed term employment, the employees get a gratuity even if they have covered 1 year of employment. Say, for example, an employee is appointed for 2 years term. So the 2 years term is the fixed term. Now that this employment will be called as fixed term employment. So if he has completed 1 year continuously in that as part of that fixed term, then he is eligible to the gratuity. The calculation of the gratuity is same as the earlier formula, and however it applies to the other permanent employees. But for that 1 year, if he had completed 1 year itself, he becomes eligible for claiming gratuity. So the fixed term employment is a new introduction under the new labor code. Then under the Industrial Relation Code, there's something called Worker Reskilling Fund that is being introduced. This is also something new because this is every employee's workers 15-day wages of last round wages. This will be contributed by the worker into this reskilling fund. So if if a worker is retrenched from the work, then he will be given this particular 15 days last drawn wages by the worker to upskill. This is basically an upskilling fund so that he can undergo some training also to upskill himself. Now, the new Industrial Relations Code has also expanded the definition of worker. So, who mines, plantation, factories, whoever works there is now was there already in existence under the definition of worker. There is usually whoever works in managerial capacity is not brought under the definition of worker. But this expanded definition brings in sale promotion staffs, working journalists, and supervisors who earns up to a salary of 18,000 per month is now all brought under the definition of worker under the Industrial Relations Code. So if there is any dispute, they can file it as a under the Industrial Disputes Act. Like earlier Industrial Dispute Act is now under the Industrial Relations Code, but they will also fall under the definition of worker. So supervisors employ workers providing supervisory function up to the earning up to the salary of 18,000 is now brought under the ambit of worker definition. Now moving on to the next code, we have the Social Security Code. So under Social Security Code, one of the very important change that has been brought in is that introduction of expansion of this coverage to gig workers and platform workers. So gig workers are none but we have Swiggy, Zomato, like everything comes to our doorstep. So all these delivery agents are called gig workers. Now earlier, as this is all modern times employment opportunities, right? So earlier laws did not address anything relating to their job. It was a very unorganized sector, but this new labor code, this under Social Security Code, they bring in the gig workers and platform workers under the ambit. So there's a broader coverage for Social Security Code. And as I already mentioned, the gratuity benefits has been extended to fixed term employees also. So earlier it is that 5 years of continuous employment, then the employee is eligible for gratuity. This is the case of permanent employee. But if somebody is employed for a fixed period of work, then if they have completed 1 year tenure, they'll be eligible for gratuity. Then maternity benefits, it was always there, and it is the same provisions under the new labor code also. Maximum of 26 weeks of maternity benefit is applicable to the women employees, and they should not be dismissed or laid off during the period of maternity. And in addition, 3,500 rupees bonus is also given as maternity bonus, has to be given by the employer as maternity bonus. And for delivery related, it is 26 weeks. But in case of termination of pregnancy or any other reasons, there is also 8 weeks leave that can be granted. Now, the new code also recognizes working remotely, like I mentioned. So if for a feeding mother, if it is difficult to come to office to work after the maternity break, the employer should consider giving them. It is not made mandatory, but it also says that employer should consider giving them remote working opportunities. So that is regarding maternity benefits. So these are all social security benefits that is covered under the Code on Social Security. Then regarding the digital compliances, yes, all these companies such as who are engaging these gig workers, they have to register the details of all their gig workers. Once the rules are notified, within 45 days, they have to do the registrations in the central government portal, and they should also be given EPF, ESI benefits. And there is also, they have created a fund called Social Security Fund. This is especially for the unorganized workers. So aggregators like the companies will have to contribute 1 to 2% of their annual turnover to this fund. Apart from that, even the labor office, whatever fine, penalties or any compounding, anything that is being done by the offices, this can also be contributed to the Social Security Fund. And even the organization, a CSR initiative, this can be included as one of the CSR initiative where a certain amount can be contributed to the Social Security Fund. So this fund is basically constituted to give the gig workers benefits of old age benefit, retirement benefits, and insurance benefits, and so on. So this is mainly aimed to benefit the unorganized sector. So like how we have worker reskilling fund there, we have a new fund called Social Security Fund under the Social Security Code. Now moving on to the next code, that is OSH code, Occupational Safety, Health and Working Condition Code. So under this code, it makes it mandatory that all kind of workers, whatever be the nature of work, they need to be mandatorily issued appointment letters. Then it also talks about, so this particular code generally deals with workers who works in hazardous industry, but generally even otherwise all industries, all establishments should ensure the health and safety of their workers and employees. So those working in hazardous environment, they should be given annual free health checkup to ensure that they are not exposed to any occupational diseases. So there should be free annual health checkup. It's mandatory. Then the organization, the employer should take all proactive steps to ensure that there is no injury or disease that's caused to the workers. So should, like, making it mandate, supervisors has to make it mandatory that they use safety gears, and the premises should also be kept in such a way that it is hazard prevention is managed. Now we have this.
Sorry, just a question here. So, is there any definition of what is hazardous and who all has to be covered under annual health checkup?
Hazardous, like there is a definition under the code which talks about like exposure to high temperature, big machineries. I mean, I'm saying in general senses. But the code defines what is hazardous environment. So it's basically industries which are into, like, say for example, a dyeing industry. The where they use a lot of chemicals, any the plantation workers, like where it involves a lot of physical labor, where a lot of unskilled laborers are also employed, where they'll be handling big equipments in factories. So in such cases, these are all considered to be hazardous environment. But otherways, OSH code not just focus on hazardous industries, but generally the employee should be the safety and safety of the employee. So there are some committees that is formed under the OSH code, safety committees. This can be there even in other organization to ensure the safety of the employees, like
So
how we have PoSH committee.
the reason I'm asking is, like, for example, see, in an IT company also, an electrician or a canteen staff, they could be working in high temperatures or with electrical thing, which is like could be hazardous for them. So then should I give a free checkup only for those employees or not for the other IT staff?
No, so that is now not considered to be included in this OSH code. So where here the OSH code is generally dealing with factories, basically. So when you talk about these IT companies, yes, it does not mandate health checkup, but of course safety measures needs to be taken. That mandate is there, but health checkup is for those hazardous industries, like factories where they work. For such workers only need to have this annual health checkup. Like the example that you're giving of like electricians or canteen workers, it does not mandate a health checkup. But we need to ensure that they're, while they are doing the electrical work, that installation, like whatever step needs to be done to ensure that they are safe, that needs to be done.
Got
Like
it.
providing them the adequate facility to, like, say they'll need big ladders or things to climb up and do the electrical work. So such facility organization need to provide. We cannot expect them to, use an improper way, in improper manner to climb up and like do something, then there is a fall and accident occurs, it will be the liability of the organization, because during the course of employment, if is a regular, I mean, on in team, like an employee also, it is even more difficult for the organization to handle that issues. But such facilities needs to be provided, yes, that is there, including for organizations such as IT companies. But the health checkups and such things needs to be provided only for factories at this point.
Ashwini, just to add to Vijay's question here, so what I had heard was the definition of the for workers itself has been enhanced, which covers everyone. So is that so, or because as I hear you now, you're saying it's primarily only for factory workers? But what I'd heard was the worker definition itself has covers everyone now under the OSH code.
No, so worker definition is given under the Industrial Relations Code, which is it's an expanded definition. So again, in that as well, like I told, the expansion is basically including the sale promotion staffs, the working journalist, then supervisors. Earlier, it was only 10 or 15,000. Now it has been increased to 18,000. So anybody drawing salary up to 18,000 is also, even though they are not workers technically, but a supervisor, it is included under the definition of workers under the industrial relations code. So the same definition is what applies to OSH code. But the point what you're saying is like what is related to what Vijay also asked is that safety OSH code generally deals, when I talk about hazard prevention and all that, it is to be done by all organization. But whether it is in hazardous industries, that like an IT company and so may not fall under that definition. So that is, don't get confused with hazardous industries
Mhm.
from safety control, safety measures. That safety measures, it is applicable to everyone, every employee, every workers, everyone in an organization. So organization has to an extent ensure that their employees are safeguarded. If you see, even PoSH is one such measure, like to ensure safety from workplace harassment. Likewise, we have, if it is providing equipments, whatever it may be, that safety has to be provided by the organization. This annual checkup and all that is what is only related to this hazardous environment, because they're exposed to like lot of chemicals and things like that. To ensure that their health is like in a good condition, they need to be a regular checkup.
Got it,
Should
ma'am.
be at the
Sure.
cost of the employer.
Got it. Sure. Thank you so much.
Okay. Yeah, then the code also provide for welfare facilities. See, this is also applicable to all the organization. This is what, like I was saying, safety and welfare. This is something all organizations should adopt, like having shelter rooms, having restrooms separately for men and women. Then there are organizations, if there are more than 50 women, they can have provide creche facilities. So if there is less women employees, there are government creche facilities that's available. So they can even, but the company should provide that information to the women employees so that they can avail such benefits. So restrooms, shelter rooms, all creche facilities, all these needs to be provided. These are all welfare facilities that an organization needs to provide to its employees. Now, under OSH code, it has also introduced women are allowed to work on night shift. So earlier also there are companies that are engaging women in night shift now, regardless of establishment. But if you see a lot of factories and manufacturing units, women were not allowed to work in night shift. But now, regardless of establishment, nature of establishment, for all types of work, women are allowed to work. And the timing will be any time before 6 a.m. and 7 p.m. It will be considered as out, like night shift hours. And specific consent needs to be obtained from the woman for working in night shift. So there should be a consent letter from them. And also the organization should ensure this adequate safety measures, like there should be proper lighting in the where they work. There should be CCTV camera. There should be cab facilities that's provided. And the cab also should have an SOS alarm settings. And there should be a security who accompanies this woman employee. So there is other such mandates to, even when an employee is allowed to work in night shift, employee in the sense women employees, when they are allowed to work in night shift, they should be provided with all the safety measures to ensure that they work safely during that night shift hours. So the organization will also have to maintain a register where they enter the name, details, emergency contact number of the woman employees who takes the cab facilities, then who pick, what time they are picked up, what time they are dropped, who is the cab driver on that day, there his name and phone number details. All these, the register also need to be maintained, and they should be given all safety measures to ensure that they travel safely after work. And within the premises also, there should be adequate lighting, CCTV camera, and all of that. So these safety measures needs to be taken by the organization. So that is a general overview of the four labor codes. Now, to be more specific to our topic, we'll be looking at the PoSH Act and the No Labor Code. So these are things that we already discussed, but I'm now just going to connect it with how it is in relation to PoSH, how this we can draw the connection. Now, with respect to expanded coverage, we saw that gig workers, online platform workers, all of them are now included under the new code. Now, when they are now included as employees, workers in an organization, then they should also be included in this PoSH policies. They should be given awareness training sessions. So if from a PoSH angle now, when we talk about employee awareness, employees concerns and all of that, it should also include this gig workers and the platform workers. So that is expanded coverage even in from the angle of PoSH compliance. Now strengthen liability. So this new labor code um, gives penalty provisions for a lot of non-compliances. So if there is like in under PoSH also, we have to do auditing, reporting, and so on. So there is more liability, complaints liability on the committee, I mean the team as well, on the organization. So otherwise we'll be exposed to higher penalty. So there's strengthened liability. Then there is mandatory night shifts, safety provisions are introduced. So this when women are working in night shift, they should be sensitized more about, the organization should also be sensitized about the safety measures that she should take. And this all should be looked in from a PoSH angle, and it should also be taken as a responsibility of the PoSH committee to share that kind of awareness, like what safety steps should be taken, what they should do, what they should not do, and things like that. Then apart from that, safety committees, OSH code also provides for setting up safety committees. So it should all, PoSH and safety committees should all work hand in hand to ensure mandatory safety and ensure an harassment free environment. Then regarding documentation and audit, now that everything is digitalized, all the PoSH related records should also be maintained in a proper manner in a digitalized form, that so that like how the other registers and documents are maintained by the organization, this should also be readily available for any inspection, and it should be maintained in a proper manner by the committee, by the IC. Now we are going to look at the challenges.
Sorry, actually, just one more question here. When you say digital, so all the records for PoSH that we were maintaining were all as hard copies. So do you mean we have to go back and make sure we have all of that scanned and kept available online, or going forward, we need to make sure?
See, there is no what you say, retrospective application to these provisions, but going forward, yes, it has to be maintained in a digital manner.
Digital. Okay.
See, a lot of organizations may be doing already digitally. They can continue to do so, but those organizations who've been handling all these files physically, yes, now definitely they'll have to migrate to a digital record keeping.
Okay, sure. Thank you.
Yeah. Now moving on to the challenges, this is also from the angle of PoSH. So the new labor code mandates, initially for the beginning we discussed that deduction in the change in wage structure. One of the important changes was that the deduction is now capped at 50% maximum. So if you see as an IC committee, one of the punishment that can be imposed on the respondent is that fine or penalty. So deduction will include this fines and penalty. So if an employee is already under a deduction cap of have attained a deduction of maximum of 50%, then it will be difficult for an IC organization to implement such recommendation of the IC, because there's already maximum of 50% deduction. So in that case, there should be an other alternative recommendation that the IC gives, or like I say earlier mentioned, though the act does not prescribe what can be done if there is an excess deduction, this will all follow in rules. Like if all this clarity that we don't have today, rules and other things are several rules are yet to be notified, so maybe that more clarity will come there. But as a team, what we can think of now is like maybe if in the next coming months the deduction can be carry forward, but this needs to be now carefully evaluated by the IC while imposing any kind of fine and penalty as a punishment, as a recommendation. Now, moving on, the next one other challenge could be regarding the grievance redressal committee. So when I was talking about this GRC, there one of you raised a question like whether this is similar to the PoSH. See, it is not. The straight answer is that it is GRC is separate, PoSH is separate. PoSH is a statutory committee formed under it's a committee that is mandated by a statute in the PoSH Act. Now, grievance redressal committee is also, yes, it is a mandatory committee under the IR code. But grievance committee has a wider scope. It can cover all kind of grievances. But this is where the organization has to clearly create the awareness to the employees that any post related complaint should be like any complaints on sexual harassment should be forwarded to the PoSH committee and not to be dealt by the GRC. GRC can deal with all the other matters, because if you see the limitation of filing complaint also changes with GRC and with the PoSH. Say here PoSH, under PoSH law, we only allow complaints to be taken up within, I mean, if it is filed within 3 months to a maximum of 6 months. But under GRC, up to 1 year, the complaints can be filed. So even if GRC receives any such complaint, they should also inform the complainant, this should be filed, the appropriate forum to file such kind of a complaint, if it is relating to sexual harassment, is before the PoSH committee and redirect the complainant, like make them aware that this complaint should go to the PoSH committee. So there shouldn't be an overlap in the functioning of this, but employee may not be aware of this. So they might, if once the GRC is formed, they may think, okay, it's a redressal committee, I can file the complaint there. So they should also be made aware of the difference between PoSH committee, GRC committee, and even the members of the GRC committee should be given that kind of an orientation so that they forward the complaints correctly to PoSH IC committee. Now,
So I have a question here. Can HR team be part of GRC?
Presently, there is no restriction. See, when IC committee, we generally don't recommend HR to be part of it. That is mainly because the recommendation is to be implemented by the organization, and that is mostly done through the HR. So,
Yes.
to avoid that kind of an overlap. But in the code, it does not say anything like it just says that employers and workers' proportional representation should be there. But who can be the representative from the employer side is not very clear. These are things the organization should think and like frame rules to ensure that this committee's purpose should be is to get the confidence of the employees. So in that case, if it is ideal to keep the HR out of this committee, it should be done in such manner. So you have to understand your organization and then decide on the composition accordingly. But
Okay.
now there is no bar on having, like, the code does not bar an HR to be part of the committee. But if you have lack of employees, because it can have maximum of 10 employees. So if there is there is a lack of having representation from employer side, if you have to include an HR, then since there is no ban, it can be done. But look at your organization structure, and then deciding based on that would be ideal.
Okay. And is there any minimum head count required for this committee? Like in PoSH, there is a minimum head count.
Yeah,
So in
at present, I did not see any minimum headcount. It's just say maximum of 10 members. But like, of course, there should be an odd number. At least minimum of 3 should be there.
3. Okay.
But then the problem is it is talking about equal representation from employer worker, right? And also talking about women proportional registration. So it is very minimum having something like that. So at least, minimum of 5 or above, 5 to 10 would be an ideal composition of a GRC.
Okay. Thank you.
Then standing order applicability. So we also saw that standing order, like now the threshold is having a certified standing order threshold is now increased to 300 employees. So that does not mean the other organization need not have a standing order, because it's very important, because that is where the rules relating to like definition of misconduct, disciplinary proceedings, all that is mentioned. So even relating to PoSH law, the Parliamentary Standing Committee emphasized on the need of having a definition for misconduct in standing orders. And so service rules and all that is very important. So even if there is a threshold has increased, the organization, for industries, it's called standing orders, but every organization should mandatorily have their service rules where they define what is misconduct, what will be the possible punishments, and so on. So if you see the PoSH Act also, you may see this provision. So everywhere there is a reference to service rules. So the Act also then lay back on the service rules to implement these provisions. So service rules, though to provide us flexibility to the organization, though the new code is increase the threshold, are more liberal with standing orders and service rules, the organization should strictly have a service rule in place which is in compliance of the new labor code. Now, another challenge is that due to the expanded worker coverage, that is gig workers are now employed. So from PoSH angle, when you look at it, whatever is the contracts or agreements that was in existence with the gig workers, that needs to be updated to include the PoSH provisions. Now they're brought under the legal ambit, so they come under the PoSH law coverage also. So the PoSH policy or of your organization also needs to be strictly reviewed to include the gig workers and platform workers. And now we have to anticipate what kind of we'll also have definition of sexual harassment and so on. So all these definition also need to be revised to include the kind of harassment that can happen because the gig worker. See, what if they're going for a delivery, the customer faces a sexual harassment because of the in from the is exposed to a harassment by the gig worker. So whether they can file a complaint under the IC. So a lot of these things needs to be looked into, and accordingly the policies needs a revamp. So all the organization has to now go back, revise their PoSH policy to include the coverage for gig workers. Now the new code also mandate a strong focus on workplace safety. So that is what OSH code, like as I already discussed, safety measures has to be implemented by all the organizations regardless of the nature. So it is that duty is on the employer to ensure that a safe, dignified, harassment-free workplace is being provided. In fact, that is one of the core objective of the IC committee also under the PoSH law. So all this needs to be aligned, and the committee has to work with the safety committee, grievance redress committee, and ensure that, as mandated in the OSH code, ensure a safe, dignified, and harassment-free workplace environment. Now, another challenges is regarding the increased complaints and audit preparedness. So we already saw this because of the digital record keeping and even the complaints is everything is done online. Like we are completely moving to a digital framework now. So there will be stricter implementation also. Right now, we are only in the phase of like moving to the completely transitioning to the new labor code. But once the transition is complete, there will be like more they'll be starting to implement these provisions, and then for non-compliance there will be penalties and so on. And earlier inspectors used to visit the premises and conduct inspection. Now once if it is all kept online and digitalized records, it will be easier for the inspectors also to inspect these records and find out any non-compliance issues. But one very positive aspect of this new labor code is that earlier it was more of the enforcement was very stricter in terms of like even penalties and punishments. This new labor code has decriminalized a lot of provisions, and but what they have instead done is increased the penalty limit. So earlier, whatever for general non-compliance, the maximum penalty was 20,000, but now then under the new code, minimum penalty itself is 50,000. So they've increased the penalty brackets, but they have decriminalized a lot of non-compliance issue. And here under the new code, if an organization does repeated offenses, they are given higher penalties. So again, not a imprisonment, but a higher penalties. And they also give an option for compounding options. That is something like settlement. So if there is a fine or notice issued on the organization to pay a particular penalty, and if the organization admits that they were wrong, like there is a non-compliance, they can ask for a compounding option where they settle that penalty by paying 50 to 75% based on the nature of the non-compliance. So these compounding options are also given. And under the new labor code, another positive aspect is appointment of inspector come facilitator. So earlier we had in labor inspectors. Now they're called as inspectors come facilitators. That is one reason being this is a new labor code. Organizations are only adopting to the new code. So they are also acting as facilitator to help you all understand what this new labor code is, what is the kind of complaints. So initially there is also a breathing space that's given to the organization. So if for in the initial phase they are planning to, like, if there is a non-compliance, giving time to the organization to rectify it, like a 30 days time or so to rectify it, and then thereafter if it is not done, only then they'll get into enforcement angle. So once we have all the rules notified, we'll get better picture on the complaints aspect, the timeline and so. But at least in the enforcement angle, the new labor code looks to be little more uh, softer, not just because it is decriminalized, but they're trying to actually facilitate. They're actually trying to attain the objective of this code by making the organization do something instead of just looking at whether the organizations are non-compliant and waiting for an opportunity to just punish them, impose fine or any other kind of punishment. Here they're trying to equip the organization to ensure so that they comply with the code. That is the aim of this new labor code. So that is why we have inspector come facilitators now. Now this is what such complaints checklist for the HR and IC. So this is just a summary of like we discussed about what this new labor code is, what are the key changes, and we also discussed about the challenges and so how as an HR and IC member, how what we should do to so that we proactively take steps to migrate to the transition to the new labor code. See, one thing is definitely the reviewing and revising the wage structure, because it is now made mandatory that 50% basic 50% cap on basic pay. Most of the organization, if you say, they would be falling less than 50% for the reason that it was more beneficial for the employer. But now this new law has made 99% of the organization is except like the government organ institutions to revisit on their wage structure. So that is the first thing that needs to be done. Then updating the payroll system, because now we have a timeline also for under the wage code, which is also mandatory compliance. So the payroll system needs to update it to suit that timeline. Like we saw, daily worker has to be paid on the same day. Monthly payment has to be done before 7th of every month. So updating the payroll system, then prepare early for FNF settlement calculation. We already discussed on that as well, the challenges that we may face. But like again, the organization, the team has to come up with some strategy to handle this, because since it's a mandatory compliance, if there is any complaint to the department, this can lead to imposing penalty. So how this can be tackled based on the organization structure needs to come up with ideas how this can be released in 2 days. Now, another important checklist is that, item is that implementing digital record keeping. So for organization which those handling the physical papers now need to have a database or a structure to move all this to digital record keeping, and timely updation of these records is also very important, so that we avoid any penalty, and at the time of inspection, so that this is all the records are readily available. So having implementing digital record keeping system and timely updation of the records to avoid any issues. Now, another important things that we need to go back and see is reviewing the policies. Leave policy, PoSH policy, fixed term employment is introduced. So if if you are an organization hiring employees on fixed term employment, now your policy should include a clause on fixed term employments. So if any rules on gratuity that is mentioned in your policy, it should also include fixed term employment now. So all the company policies needs to be reviewed. So now most of the organization, after the new labor code came, the first two items that the organization had picked up is like, one, to revise their wage structure, and second thing is to go back to their policy and reviewing their policy. So this is what is happening. So one very important thing that needs to be done is reviewing all the policies of the organization, and to ensure that it is up to date with the new labor code. And this is going to be a continuing process for some time, because as I told you, we are only in the process of phase by phase manner. This is getting fully implemented. So with the changes, new rules and things, there can be constant updation for a while now. So this can happen, but it is important that but you constantly keep it updated. You cannot wait for everything to be fully implemented to do, but at least for the time being, you should start relooking into your policies to keep it updated. Then train managers and HR teams. Yes, because this is a new law. It's an evolving law. Nobody is now fully educated on what is covered, what is not covered, and things like that. But eventually there will be more clarity. So it is important to train the managers, HR. I mean, today you're all here as part of that initiative, but there should be constant training and updation. That is very important. So you should organize training within your organization for to be updated with the new labor code, and also have employee awareness session. Like as I mentioned already, the employees are little undressed, because with the new labor code, they are thinking that it's an understanding that the take home salary is going to be less. So this has disappointed a lot of employees. And mostly what happens is the employees, since the new law, there is a lot of information available online. They read all that with half-baked information. They are expressing their disappointment. So though maybe the take home is going to be less. It can happen, but eventually it is going longer. They have longer benefits because the retirement benefits and all that is going to be increased because of more PF contribution and so the employees need to be aware of this. So as an organization, instead of them receiving all this incomplete information, the managers and HR team can plan awareness session for the employees to make them understand this is what the labor code is, explain them the wage structure so that they understand the benefits that they'll derive out of it also. So there is no dissatisfaction among the employees. So this can employee awareness sessions can also be done. Then it is, of course, by reviewing the policy itself, we will be able to understand, do a gap analysis, like where we stand and how much we need to, update to match the new labor code. So that analysis has to be done so that the organizations are fully compliant with the new labor code. So these are like few checklist item for the HR and IC team. And this is like, I'm going to conclude the presentation because it's almost time also. So this is the implementation roadmap for the new labor code. So we started from November 2025, that enactment of all labor code happens. Now in 20, if you see Q1, Q2, Q3, Q4, like the entire 2026, they have planned in phased manner of introduction of rules and regulation. Then Q2, they're looking at registering an online complaints portal. So even the online system of the government is also not fully ready. So all that is under process. So that is also targeted to be completed this year. Then slowly, the organization should also step up and do full compliance of changing the wage structure and so on. Then finally, by end of this year, they're planning to fully implement the new labor code. And from next year onwards, like there will be like complaints, inspections, and so on. So that is the time that the organization have to adopt, transition, or migrate to the new labor code. So now that's about the new labor code. So if you look at the new labor code, it is now, cannot say very employer friendly or employee friendly, but they try to revamp a lot of existing structures, bringing in new expanding the coverage, bringing in new kind of employment under the ambit of the authorities and so on. And as HR and IC members, what I want to tell you all is, like, we saw the checklist. So these are your items that you need to proactively act upon. So those organizations which are proactively taking steps, it's easier for them to migrate and adapt to new labor code, because eventually this is going to be the law. So earlier the better. That would be my suggestion. Have a complaints calendar so that at what, when the registration has to be, everything has a timeline. So have a complaints, if you already have, just update it based on your industry requirements, update it based on the new labor code, keep it updated so that, and stick to the make all your team members aware of it and stick to that compliance calendar, and start moving things, slowly pushing, like you may start with review of policies and so on. So changing wage structure, maybe a lot of organization had already done. So keep things moving so that whatever the timeline that the authorities are looking at, we'll also be equipped to fully migrate to the new labor code along with them. So if you have any more questions, we can ask. I've taken exactly that 1.5 hours, but I'm happy to stay back for some more time if there's any questions.
There are some questions listed on the chat window, Ashwini.
Yeah, we'll just, I'm sharing. I think overtime related question by Tejashree I've already answered. So 12 hours, 8 hours is the normal working hours, and it can expand up to 12 hours. That is what the new labor code says. And maximum of 48 hours in a week. See, does this 30 days, Soumya's question of whether 30 days for inquiry, including weekends and holidays, or only working days? see, even ideally, like we are now looking at Vijay for PoSH also we only
Calendar days.
yeah. So we
Calendar
need
days for PoSH, Ashwini. So I had a question if it is the same calendar days for, GRC also to complete the entire.
yeah, because it actually says 30 days, within 30 days. So generally in all these cases, we don't go by the like any calculation of limitation. We don't go by working days. So we just say always calendar days. So it will be the same that's applicable for GRC as well.
Understood. Thank you. And couple of more questions. What is the rest interval defined as per the new labor code?
See, every 4 to 5 hours there should be a break.
Okay, the number of hours for break, 8 hours work hours is
Two
effective work hours.
intervals. Yeah, two intervals.
30 minutes for every 4 hours.
Okay,
And
thank you.
two intervals should be given.
All right. And another question is there a definition for a manager in the new labor code, and will the managers be eligible for OT? And just a manager title, I don't think will make them fall under the manager criteria. So what is the criteria that we need to consider?
See, correct. So, if you look at the Industrial Relations Code, it talks like I've spoken about the expanded coverage, right? Like including the journalists, supervisors, and so on. So it says who not included as managers. But if you look at how the codes are interpreting this, is like a lot of times manager title is being given to employees who does not perform managerial functions. Like whether you have the power to fire or hire, whether you have the power to sign. Checks on behalf of the organization, any financial transaction can gain there are a lot of checklist for whether to find out whether you actually fall under the definition of a manager or not. So this interpretation is done a lot by the courts. So a lot of times the organization take a stand that it doesn't fall under the definition of worker, but courts have interpreted it differently, stating that even though you call a person manager, if he doesn't do all these functions, then he's not a manager in a technical sense. So in therefore it should be given the benefit what the workers get. That is how it has been interpreted. So similarly, new code also in the industrial relations code as well exempt managers. That is why they say supervisors, but up to the age salary threshold of 18,000. So what they then mean is that anybody who earns more than 18,000 doing supervisory roles or any managerial role will not be included in under the definition of worker. But
Okay.
there are the other acts also, like even this working hours and all that is also governed under shops and establishment. But these are all state acts. Now, this new labor code, as I mentioned, it is subsuming 29 central acts. So they are not talking about the states act, but every state have its own shops and establishment acts and so on. So, like regarding termination of manager and so on, is now covered under the shops and establishment acts as well. Like the termination can be challenged. Like a lot of times, this managers doesn't go under the earlier scenario under the Industrial Dispute Act, because they may not, there is always a confusion whether they fall under worker definition. So they used to challenge it under the Shops and Establishment Act. So such things will continue.
Okay.
But yeah, managers are still not under the worker definition.
Understood. Thank you.
Ashwini, we have few more questions regarding crèche facilities and freelancers, consultants being fixed term employees. I'll read out those questions for you.
Yeah. One other thing, Raj has suggested that, like, that regarding that labor code coverage. See, the reason why I touched upon that labor code is when I discussed the challenges, you would have understood. It was like just me connecting to that labor code, whatever I've explained. So, without understanding what this new labor code brings in, then we'll not be able to discuss on other aspect also. So, that is the reason why I've covered the four codes. Okay.
That's fine. That's fine.
Yeah, because I just had to connect it to the challenges because most of it was already
I
discussed.
understand.
So I have a question. Right now we have only the handbook which gives a brief guideline. When are the SOPs going to be come into picture? So is there any timeline on the SOPs for the implementation?
So we saw that slide on implementation timelines, right? So by quarter 4 of 2026, they're planning to have it fully implemented. Right now, the phase is that there are certain draft rules that is being circulated, which comments are asked for. So all that process, once the comments are taken and like once that revisions is done, this rules will be notified. And they're also now working on state specific amendments and state specific provisions and so on. So only it is a very in a phased manner. It is moving towards a complete implementation. So this will slowly come into place.
So these
SOPs.
penalties and all will be implemented only from the next financial year, or they will be
That is
implemented?
what ideally the implementation calendar looks like, because once it is fully implemented, then the organization should also get equipped to handle this, right? So after that only they'll be like fully enforcing the penalties and so on. But that is not a, I mean, that would ideally happen, but that is not a reason for the organization to wait till
Yeah,
it is completely implemented to do anything. We should always like, because it would be difficult to suddenly transition to this new system. So organizations are also given this time to equip themselves. So let's
correct,
not
correct.
wait
Our
till that
major,
time.
yeah, yeah. Our major challenge was on this two days full and final settlement. What in
Hmm.
case of employees who are terminated, absconding? So we wait for them to finish the exit formality. So we cannot go ahead and complete, the F and F. So our major challenge was in that case. So that is why we wanted to understand on the penalty part.
Yeah, I know, I understand. Like out of all the provisions that I've seen, even to me, what seems to be more challenging is this one
Yeah, it is
provision.
not practical, feasible
Uh,
2 days timeline. Because
yeah.
we also have a process wherein our payroll is like processed through a third party. We have to send the details, and in case of
Mm,
termination and all those kind of a stuff, we have to send details, and the details come back to us, and we have an accounts who will work on it, process, and then there are many approvers for the e-check and all those things. So
mm.
practically, it takes a week.
No, understandable. Like this is the feedback that's given by most of the organization. I haven't heard any organization telling that, oh, like we can do it in 2 days. Like everybody is only raising questions on how it is practically possible. So that is why I'm saying once the rules and all that comes in, there can be some relaxations on this. Like we have to wait and see. But now it is a mandate, and it says all wage related ingredients has to be paid within 2 days. That is what the code says. But let's see what it's gonna come up in the rules. But like, let's also break our heads to like find out possible remedies in case to handle this in the 2 day within the 2 days.
Right.
Any more questions from anyone?
I have a question regarding the GRC. So, is it mandatory for all the companies in all sectors?
No, so it is mainly for it comes under industrial relations code. So whatever is the employer employee under the industrial relations code for them. Like for IT companies, you need not have a GRC.
Thank you.
I have a question. See, as we discussed earlier also that FNF to be processed in 2 days, but rules are not yet notified. So, few employees are complaining that this has to be done in 2 days. Otherwise, we will do the complaint against the organization. So, how we can tackle that?
Oh, you're saying that already the employees are intimidating, I mean, threatening of legal action?
Yes, yes, yes. Because they are searching
Mm-mm.
on ChatGPT and just
Yeah.
doing a mail. Right.
This is why I was telling that employee awareness is also very important, because this happens like a lot of times they'll go find like a little bit of information here and there and coming. But see, now it is not a legal mandate as of today, right? Like to process that. So you can respond to them officially itself that we are in the process, and it is not made mandatory. So not to give in to that such threat. And but of course, we like whatever parallelly, however you have to process it at the earliest, that can be done. But you can write to them that this is not in effect in the complete implementation. So we will process it as per our policies. You can just give such a kind of a response now. Because if they take it to the inspectors and so on, you will have the leverage to say that this is not fully implemented, we are getting things done and all of that. But that is only when it goes to a complaint stage. But right now you can just give an official communication to the employees, whoever is stating that it when the process of doing it, we will do as per the company policies.
Okay, thank you.
Hi, Ashmi. I have am I audible?
Yes, yes. Tell me.
We're a staffing company. We've been supplying staffs on a contract basis as well. We have this arrangement where we supply contractors without the contractors as well prefer not getting PFs and other statutory benefit. They work more like a freelancer, but we treat them as an employee. I mean, as a contractor. Even though they work like a freelancer, they are exclusively tied to us. Is it okay that we don't give them PF and treat them as a freelancer, but an exclusive freelancer?
No, no, okay. A second, there's someone's. Okay, can you? I lost you in between. Like there was some disturbance. Can you repeat the question?
So maybe I'll take that question. See, I think if are you the principal employer?
Yeah, the
Are
contract.
you paying them salary directly? Are they on your payroll? Then you have to take care of all the statutory benefits. But if you have hired them through a contracting agency, then they'll be treated like a contracting where the contracting agency will have the statutory responsibilities.
We
So
are the contractor here. The
you're
question
the principal employer.
the contractor.
Oh, you're the contractor. Okay.
So we supply the candidates to the client, the principal employer.
Okay, so you have to then take care. You have to own the statutory benefits for all those employees, all the staff, because they are under your payroll.
No, they won't be in our payroll, but we'll be paying them on timesheet basis, and they will also be an exclusive resource to us. We
Yeah,
just
but
name them as contractors. We name them as freelancers, and we give them compensation on a timesheet basis.
but again, your master supply agreement with the other, like your principal employer, will specify, right, who is going to bear the statutory.
Yeah, because again, the term freelancers is something where they are free to engage with anybody. You don't do that. You have a mutually exclusive agreement, right? So you can't call them freelancers and not give them benefits. If it goes to any authorized bodies like PF, ESI, they're gonna come and tell you that you need to give them all the benefits like a full-time employee.
Oh, I understand. Like, what if I term them as contractor, make them an exclusive employee, exclusive personnel, and not give them PF? But it's still a
No,
breach
if
of
your contract is going to say that they should not engage with any competitor and other things, then you are tying them to you. Uh, that is legally, going to make you weak.
Okay.
Yeah.
And
I
see,
understand.
now new labor code also talks about this fixed term employment, right? So all this what you're saying as contract, contract employees, they'll get covered under that. And another thing is that this master service agreement, which I mentioned, it will definitely have a clause with relation to who is going to bear these expenses, who is going to do that contribution. And the if there is more than 20 employees engaged in under your payroll, then definitely you have to pay PF for the employees. So these
Oh,
are the statutory requirements. So you will fall under all of this.
okay. I understand. Thank you. Thank you both.
So if you're good, then maybe we can wind up the session. Vijay, anything, any more
No, I
questions
think
that anyone?
the feedback for the session has been launched. If everyone can give the feedback, that'd be great. As well as in case if you would like to have any more sessions similar to this, please do write to us at connect@securus.com, and we'll be happy to conduct similar such sessions. I've also shared a blog link specifically for PoSH and the new labor code impact. Please do take a look at that in the chat window.
Thanks, Vijay.
Thank you.
Thank
Thank
you
you
all
all.
so
Thank you
much.
for
I hope
giving
all
us.
of you had some idea of like some clarity on this new labor code. So I hope this session was some way helpful to each of you.
It was. Thank you.
Thank
It
you for
was
your
Thank
active
Ashwini.
you.
participation
Thank you.
also.
Thank you.
Thank you.
Thank you
Thanks,
all.
Ashwini. Thanks, Vijay. Good day.
Thank you all.
Thank you.
Thank you. Thank you, Ashwini. Thank you, Maha. Thank you, Neerja. Thank you all.
Thank you, Vijay. Thank you, Maha. Thank you for coordinating it so well. Thank you.
Thank you. Thanks, Ashwini.